welcome. If you're coming on, you already know us at Snyder Law. My name is Kevin Snyder. I'm an estate planning attorney. I'm a business attorney. We work with elder law and veterans, and we can also help families that have gone through a crisis, whether it's a medical crisis or there's been a death. So that's what we do. We help people plan for the unthinkable, and then when they're going through the unthinkable, we help the family. So that's what I really like doing, but the reason why I like doing it is because I get to meet all of you and walk through life with you for a moment. You hear your story, hear your family story, and those are treasures. And being able to help and assist and providing some insight into a very complicated sometimes situation and process. So that's what we're going to do today. We're going to talk about the ABCs for successor trustees. And this is important if you have a plan that's already set up. And a lot of you that have come onto this webinar have come because of just that. You set up a trust, you designated people to be trustees, successor trustees, and they now have a job to do, or they will have a job to do. So this works for both. So some of you may have set up an irrevocable trust and you're alive now, but you set up a trust for somebody else to run and be a trustee. Or your more common situation probably is that you've created a trust, a revocable living trust, and in the future, should either you pass away or you become infirm in the sense that you're in the hospital, you're unconscious, or you have a medical event in which makes you incommunicative, or from a dementia standpoint, you no longer have the ability to really rationalize. That standpoint, you have somebody else stepping in and managing the trust to develop or to orchestrate the outcomes that you want, that you've created the trust to do. And these are called your successor trustees. So what does it mean to be a successor trustee? What kind of job and role? What does that really deal with? And guess what? The little hidden secret is that the trust doesn't really all lay it out. Now, it lays out a lot of things legally, but it's not the complete playbook. And if you stay on for the whole time today, I'm just going to preview it. You will get an opportunity to get a little gift. We'll have a little offer there for you and this idea of a playbook. So if we look at it from a standpoint of a playbook, there's really two playbooks. There's the trust, and then there's the other one we're going to talk about today. Your successor trustees need to know about both of them in order to be successful successor trustees. And we want them to be successful because it's very expensive to be unsuccessful, because usually there's some court involved and nobody wins when things go to court. So a little bit quickly about me and who I am. I mentioned that I'm an estate planning attorney, but I'm also a husband, a father, and a son. Among other things that I do, being a coach, being a cartoonist, being an author. These are just things about me, but that my why and my reason of doing this is because of family. And that's at the center and the core of why all of you have done your planning, is because you want to leave a lasting legacy of some sort to your planning. Legacy doesn't mean, oh, I'm going to leave huge amounts of money and we're going to be like the Hershey family and have money that transcends generations. It could be that, but it might also be, I want them to remember me in a positive way and have the memories. We've gone on trips like this and we remember the good times moving forward, not the challenges. And certainly what we don't want to do is make things challenging for our family when life is already challenging, when we're sick and infirm or we've passed away. These are challenging times that we don't want to make extra challenging because we didn't plan well, or we didn't think about what things could happen. And now when we didn't intend to, we've left the mess. Now you said, okay, well, Kevin, I created a trust, so I, of course, trying to avoid that mess. And didn't I avoid that mess because now that I have a trust, things are not going to go through court and probate. So what's the purpose of this conversation other than I just want to know what my trustees should know? Well, look, that's where the mess can come in. We can have a beautifully organized and written plan. It's in a nice green leather binder. Some of that might be familiar to some of you on this call. A nice paper looks really good. And then in implementation, it's not good. Why? Because humans are the implementers. The trust doesn't isn't magic. It doesn't go into effect by itself. It's operated by humans. And so humans with all of the baggage that comes along with that. And in particular, if we're working with humans that are family members, or there's always family dynamics, no matter what. And certainly things get heightened after there's a death because there's emotion, because we're human. So the human element is something that is important to consider when we're looking at the roles and responsibilities of a successor trustee and what they need to do and what happens, because that is the big disruptor here, is the implementation by humans on a plan that otherwise is in a vacuum, is going to be working just fine, falls apart. But the good news is that there's things that we can do ahead of time with our planning to kind of foresee the potentials of that and get in front of it. And one big thing is what you're doing today, getting educated, coming on and learning today about what it takes to be a successor trustee. So then you can go back to your plan and say, huh, do I have this thought out well enough? Or have things changed? And what I learned from Kevin today and going through this, maybe you go back and look at your successor trustees and say, is this still a good person? Is this still a good fit? Either because you are independently looking at it, or you're having a conversation with your successor trustees and sitting down and you're letting them know, hey, this is what it's going to take for you to do this well. Are you still up to the task? And it's okay if you're not, because that's fine. There's no indentured servitude here. We want people that are going to be able, and people that are going to be responsible, and people that are going to be available. So if they're not available, whether they've died, whether they've incapacitated, of course, but from a standpoint of this, they're just too busy or no longer feel that they're up to the task, they can resign. And or if they feel burdened emotionally, they're going to keep the job and they're going to do a bad job. So we want to be them to be honest with us and say, it's okay if you don't feel like you're up for the task. I'd rather you tell me now than try to suffer through it and do a bad job of it while you are well intentioned, because the outcome's still the same. Okay, so what we're going to learn today is how a living trust, what it is, just really quick, how it works, just as a fresh reminder, but heavy emphasis on the role of the trustee and what that really means, because you say, okay, they're in charge, but what is it that they actually have to do? And so into that, we're gonna transition to the successor to-do list. So these are the things, obviously, that successor trustee needs to do when they're acting in their role. Conversely, I think it's important for you to also know what a successor trustee should not do. Some things might be obvious, like don't steal the money. Well, what does that really mean, steal the money? Because they might steal it inadvertently. So we want to talk about things that they shouldn't do so that they don't get in trouble by mistake. And certainly things that they shouldn't do just in general on purpose. And then lastly, we'll talk about this trustee handbook. So if you stay on for the entire call, I'll talk to you about the trustee handbook. This is the other playbook. So it's kind of like in and out. There's a secret menu when it comes to the law in California and in any state when it comes to administering or carrying out a trust. So it's not just the trust, but there's also this secret menu, the law, and the knowledge is imputed. What does that mean? The law says you got to know all the law. Well, I didn't go to law school. Why do we have lawyers if we're just supposed to know the law? Well, the law doesn't care. Lack of knowledge is not a defense in any facet of the law. So that's why we do have lawyers, so that the lawyers can be specialized in their area, so you can consult with a lawyer and they can guide you. They can guide your successor trustees through the process so that they don't violate some rule in the hidden secret handbook. So we're going to talk about that handbook at the end, and there'll be an opportunity for you. All right, so going through this, a little quick legal disclaimer. Some of you on this call might be clients of ours already. So that's because you established an attorney-client relationship already. This webinar does not establish an attorney-client relationship with anybody on the call. Anybody who is coming onto this Zoom here, this webinar, from out of state, just know that these laws and things I'm talking about today are applicable only in California. So other states, there's some idiosyncrasies. Some things, the general process might look the same, but there are some nuances, and I would advise you to speak with an estate planning attorney that does trust administration in the state in which you're going to be living and acting as a successor trustee as well, even if it is your parent or somebody else that has set up this trust here in California, because now you're going to need to know two states' laws. For today, we're just going to talk about California, so it'll be helpful and important for you to know that. So this is not a waste of time for you, but just know that it might be, you might also need to know a little bit of a nuance for whatever state you're in. This is not legal advice, in the sense that I'm not your attorney for you. This is general information, and we always suggest you consult privately with an attorney, and that's what I'm here for. So, if you have created a trust, or my team has helped you, I've helped you create a trust, we are very open to speaking with your successor trustees and advising them. If you don't have that relationship and you come in here new and fresh, then we're happy to be available for you, as long as the assets, the trust, you, or any combination of, are here in California. Okay, enough disclaimers. And if it doesn't say micro machines, it's not the real thing. I feel like that. So all this legal stuff I say really quickly. Important. State Bar says that I need to do that, so I do that. So let's move on. So what is a living trust? It's a legal document that expresses your wishes. It holds assets, and it is implemented by trustees and successor trustees. We talked about that, right? You know that, you have one. This is something, it's like a will, except it's better than a will because it actually will avoid probate, but it's naming people that are in charge, and it's dictating what's going to happen with your assets if you become incapacitated or you've passed away. Boom, that's a trust. All right, well, when you create a trust, we have to put assets in the trust, right? That's your treasure chest, as we call it sometimes, when we put all our assets, our house, our bank accounts, our investment accounts, any CDs, 529s, any of these financial accounts go into the trust. This process is called funding, or aligning assets. We're putting them in the trust. We're changing title over into the trust so that the trust can control. For a person you've designated as a successor trustee, in order for them to have authority, legal authority over an asset, that asset has to be titled in the trust. If it's not in the trust, guess what? Successor trustee does not have legal authority. Now, that could be a problem at your death. If it's in your life, that's why we also have a durable power of attorney. And usually our practice is, and many others, sometimes it's different, but that's why we have a set of people that act as your attorney in fact under a durable power of attorney. Oftentimes these are the same people that you're choosing to be your successor trustees. But that only works if you're alive, because the power of attorney ceases to be applicable legally. It terminates upon your death. The POA dies with you. So then we need the assets are either controlled by the successor trustee, or they're controlled by the executor of your estate. So that's a problem with the executor of your estate, because that probably means probate. Most common asset where that happens, where it doesn't get funded into the trust, is a piece of real estate, usually a house. Why? Because the work wasn't done initially. Or it was done initially, but it was taken out of the trust because there was a refinance, and the lender in the process took the house out of the trust by deeding it back to the people who, the lendees, you, when you were refinancing your mortgage, and they never deeded it back into the trust. A lot of people, this is the most common scenario where there's been a mistake and the house is outside of the trust. So takeaway from today, go check your title. If you need some help, we're here to help you. We can do that if you're a client. Make sure that it is exactly titled in the trust. You have the most updated deed that reflects how your house or other real estate is currently being held. Because if there's a mistake and it's not in your trust, then you want to quickly fix that before it's too late, because then it will be in your probate estate. Then your executors have to deal with probate court in some fashion. Just a little plug, we're going to do a little webinar on the Hegstead hack and super Hegstead. So that's for a situation where you have property like a house outside of your trust and you die and it's in your estate. How do we bypass probate in that situation? We have some really cool and creative solutions there called a Hegstead hack and super Hegstead. And we will talk about that in a future webinar. So just a little plug there. But for today, we're talking about what is your successor trustee going to do? Let's assume all the assets are in the trust. What is the job of your trustee? Well, during your life, it's business as usual, right? You're in charge. So like I say, it feels like nothing's changed. Legally it changed on paper, and that's significant, legally significant, super important. But the fact that the deed to your property says, hey, it says Bob Smith, trustee of the Bob Smith Revocable Trust. Well, guess what? That's different legally now, but Bob Smith still can live in the house, can refinance the house, can sell the house, still has full control. Same with all the other assets. And if you have a revocable trust, if you remember a revocable or revocable, depending if you say tomato or tomato, it is changeable, amendable. If it's irrevocable or irrevocable, then there is some fixture to it, static. Then the rules cannot be changed. Most of the people on this Zoom right now, I'd be willing to bet we have a revocable trust, at least in part, set up. Then you can make changes. Doesn't matter whether it's revocable or irrevocable, there's still a trustee who's in charge. There's still successor trustees that are in charge when the original trustee or the initial trustee cannot be. So this conversation about trustees applies the same, what we're going to talk about today, whether you have a revocable or an irrevocable trust. There's some more advanced trusts out there where the trustee has some additional responsibilities. For example, if you have an ILIT, an irrevocable life insurance trust, there's some additional responsibilities. We're not going to get into that today. Again, little plug, we will get into that in another webinar on another month to come, so look out for that. That could be helpful for a lot of people, particularly when it comes to tax planning, and asset protection planning. So we'll talk about that, but we're just going to talk about general things that apply to successor trustees of any type of a trust. So if something happens to you as a trustee, you die or become incapacitated, your successor trustee then comes to the rescue. All right. Now this person, let's talk about if you are incapacitated, this person is your gatekeeper. This person is now in charge of your finances, that has control of the assets in the trust. You remain the beneficiary. So while this person, the successor trustee, has legal access, they have not inherited. They have not, nothing's transferred to them. There's no ownership. They simply are responsible. And the key word on responsible here, because there is a lot of legal liability with becoming a trustee. I tell people, look, it's like somebody, your mom, dad, best friend created a trust and they gave you a wrap box and it said, here's a present for you. And on the card says, do not open this present unless I become incapacitated or I've died. And you're like, okay, all right, that's weird, but I'll keep it around. And then you become incapacitated. And then I say, oh, I pulled out the present. I remember because it's kind of a weird gift and I've kept it here and now you're incapacitated. And now I open the present. You open the present, open it up, and there's a shirt. And you pull it out, and it's on a white shirt, and there's a big target on the front. And you turn it back on, there's a big target on the back. What the heck? Well, that's exactly what a trustee. They're a target for other people to attack because they have a lot of responsibility. So this could be the worst gift in the world for somebody. Why? Because, well, what if they're one of your children? They're your oldest child because you followed the protocol down the line. Well, I'm just going to name my children in order. I have three, and I'm going to go 1, 2, 3 successor trustees from oldest to youngest, the birth order. A lot of people do the birth order alignment in their successor trustee. So now you have one child managing assets, and the other children don't have authority and don't have access and control. And now you have 2 versus 1. Maybe 2 becomes suspicious of what the 1 is doing, or the 1 now is overburdened and becomes a little bitter that they have to do all this stuff. And why did mom and dad give them responsibility to do all this stuff, and the other 2 get to sit back and do nothing, but yet still benefit? So that's the target. Or there's suspicion that something is being done incorrectly, or there's an oversight, things are taking too long. Guess who gets shot at? Figuratively, hopefully, is the person wearing the Target shirt. You're not Target, but the Target shirt that I'm talking about, that's the successor trustee. So that's the downside. But on the good side, this person is putting that on, and they're a type of person that is going to have the extra Kevlar to put on over that Target shirt. And because they are responsible, they're resourceful, they take this seriously, they have the bandwidth in their life to deal with this and not just have this as a side project. That person is going to be your personal gatekeeper and advocate for you and make sure that you're well taken care of financially and legally. So you need to make sure when you're looking at your trust that these are the people that are named in your trust, because things may have changed, right? If you're on this Zoom and this webinar and you have done your trust several years ago, you've gone through this discernment process, hopefully. Some of you may have gone through it quicker than others. Some of you may have applied the rubric that I did, the analysis, not that I have myself, but the analysis I just mentioned. We did birth order, and they said, oh, that's fine with that. Or you had parents that you put on there because you were younger, or you used the people that you wanted to be legal guardians for your children, but now your children are adults, so you don't need the legal guardians. And that made sense then, but it doesn't make sense now. So we need to go back and look at who your successor trustees are and go one by one down the list and say, is this person still good for the job? Is this the right fit? Is something changed in my life or their life that would make this not the right fit for the job? And it's okay, you want to identify that. And don't use the blood is thicker than water kind of mindset, because actually blood actually can create some issues with family dynamics. There might be a situation in which you don't want someone in your family, even your children, to be the successor trustees because of family dynamics. And I encourage people not to have the Pollyanna stick your head in the sand, rose-colored glass viewpoint. We're not talking to your neighbors and your friends and saying, "How's life? Everything's great. How are the kids? Everything's great." No, we're not doing the Facebook, Instagram approach. You're looking internally at your own family. Be honest with yourself about what is actually happening. Get informed. There are always dynamics in families. You have your own siblings, perhaps. You've seen others and how things play out. Your kids may be wonderful people, and for those of you that are clients that are on this webinar, then I know your children from what you talked about. And so for many people, hey, we have all of our children are wonderful. At least some of them are wonderful in the sense that they are well-adjusted adults and they are providing good service to the community and they're productive members of the community. But do they all get along? Right? We're humans. That happens. You can pick your friends, you can pick your nose, you can't pick your family. And so sometimes that a lot of times that plays into it. So just be honest when you're assessing this, because things that they might keep suppressed and quiet now are going to play themselves out in full, unabashed, chaotic glory after you have passed, or there has been a medical event where you no longer have capacity. So we don't, at that point, it's going to be too late to make changes and updates, and you don't want your plan to fall down like a house of cards because you were not honest in your assessment. If you need assistance making the assessment, you want another viewpoint, bring in your spouse into this assessment, of course. But if you want a third party neutral, then that's what we're here for. So particularly if you are our client of ours, you're a client family, then we do those trust reviews. That would be a good idea, and we could talk about it. We could deep dive into it. I can help give you my perspective on the situation, because it also might be complicated upon your assets, or you have a business and you want one child to succeed in the business, the other children aren't interested. Well, what's that going to look like after you've passed away? The resentment, is there going to be inequities? We want to be clear on that. Is there going to be a power grab? We want to be clear on what's going on, particularly in blended families, right? So the point is, if you also are not a client, then you're welcome to have your trust reviewed by me and my team, and we can give our honest assessment on lots of things in your trust, but certainly your successor trustee lineup. So having the right people for the role. I get asked all the time, well, does the trustee have to live near me? No, the trustee does not have to live near you. We have these wonderful things called technology, Zoom, cell phones, everything's online. Financially, people don't even go to the bank anymore. So a lot of things we can do remotely. That said, it might be a good idea if you do have a trusted person locally, because it might involve keeping an eye on you if you're still alive. Of course, if you've passed away, it might not be as big of a deal, but if you might need somebody that understands what's going on locally, it could be a lot easier. If you have somebody that, of course, that does not live in the country, they're a non-resident, non-citizen, that could be an issue. In fact, we can't have them be a successor trustee if they are not a citizen of the United States. So that is something that we need to talk through. There are alternatives. We have workarounds here, but if physically they're a citizen, but let's say they live in Japan, or they live in another country for whatever reason, they're the Peace Corps, their company sent them abroad, whatever they're doing, they're not living here. The time difference alone could be make a huge enough headache that that might not make sense. You might want to put them down on your list, not have them be the primary successor trustee. So, lastly, when it comes to dynamics, things that we want to think about is well, maybe I don't have any of my kids be the trustee. Maybe I don't have any of my family members become the trustee. Why? Because my brother or sister, they're older, they're same age as me or older. All that's going to do is create a situation where I've become incapacitated, and then we look to my brother to be successor trustee, but he's already in memory care. How's that going to work out? Or he died. Well, if he died, all right, we go to the next one. But harder is a situation where brother, in this example, lacks capacity, has dementia, and how do we move the person down the list? Well, the trust tells us, well, if to be incapacitated, we need to have what? A doctor's evaluation. In some cases we can do some creative things. Maybe we create a internal independent panel of people that knows that person or knows you, and they get together and their majority opinion decide that you lack the ability, or the current named trustee lacks the ability to manage finances. Well, with a signed declaration, that moves the needle down to the next person. Or it's one doctor or two doctors that need to evaluate. Well, what's a doctor? Is it a physician, or are we going to also include a neuropsychologist and a psychiatrist, both of whom are types of professions that make these decisions? Now, a psychiatrist is a physician, so no issues there, but a psychologist is not a physician, and a neuropsychologist might be a more available choice to do a cognitive evaluation. So we want to make sure that we understand how this all works and what we're choosing. A great solution to against having aging successor trustees, against having children having to be in charge of siblings having to be in charge of each other, or sibling rivalries, or if your family has harmony, the last thing we want to do is disrupt that. So we don't want to necessarily include them into trustee roles necessarily in certain situations because we don't want to rock the boat. What's a good solution? Professional fiduciary is a good solution. And that professional fiduciary is a licensed profession. You could be a corporate fiduciary, you could be an individual fiduciary, or you could be part of a firm of a partnership of few professional fiduciaries in the middle, right? So you have basic, standard, deluxe in these situations. And they're good options because they're third-party neutrals that are regulated by the state because they have a designation, like a doctor, they have a license, like a doctor, like an attorney, like an architect. They have a teacher, they have a license. So this is a regulated industry. You have to pass a test to get it, and you're monitored, and they could take licenses away from people. And I get told, oh, I've heard horrible stories having somebody that I don't know come in, like an attorney or CPA, and they run off with the money. Well, there's always the bad apple and the bad egg. That's why you want to vet the situation, but you don't just want to use any attorney. You just don't want to use any CPA. You want to use a professional fiduciary. Now, they could have a legal background. They could have a background in accounting. They could be an attorney, licensed CPA. But if they don't have the designation of professional fiduciary, they're out. They are out. So we want them to have that designation. Now, corporate fiduciary is like a bank. So Wells Fargo Private Bank, Chase Private Client, Farmers and Merchant, who we like very much. They have a great trust services department. All the big box banks do. Fidelity does. Vanguard does. Then you go into companies that just do specialized trust services, like a Northern Trust, a Bessemer Trust, a Whittier Trust. Usually they're dealing with more high net worth individuals, and there's minimums there because they operate and offer more widespread services that an estate of that wealth might need. We call that family office. They have the CPA, they have the financial advisement internally. They have people that know real estate internally. So it's a one-stop shop and it makes a lot of sense. Particularly if you have a vast estate or complex estate, maybe you own commercial properties, rental properties, your children thrust into that role might not have the same acumen. Now they can go hire people to do that, but that might just be too much burden and put too much of a target on their back. Because why? Now, not just that, hey, look, there's family members that might be shooting at them, but also so can the tenants. Now they're assuming all of the liability of the trust. Now they don't assume debt. So if you have debt when you die, your trustee does not underscore assume the debt, but they do assume liability because if they screw things up, then guess what? The aggrieved party is going to sue the trust, and the trust is, yes, it's an entity, but it's run by a person. So they're going to sue the trust via by suing the trustee. Now, suing the trustee in their capacity and their role, right? We're going to say you screwed up as the trustee, so I'm going to sue you as the trust. That means that they can go after all of trust assets. That means that the trustee can spend trust assets in their defense by hiring a lawyer. That's good, but it's also going to bleed down assets in your estate. And they can go after the trustee personally, potentially, if that person of the trustee did something of gross negligence, meaning that they just weren't paying attention. And they should have known, but they didn't, and they should take reasonable steps to know, but they didn't. And they just said, I'm just gonna do what I want, or I'm just gonna follow this trust, and I know how to do this. How hard can it be? Those people in that mindset, those people are gonna be liable personally if there's a mistake, and likely there's gonna be a mistake because they don't know about the secret menu. And so I know I'm tempting you guys on this webinar because you've been staring at this nice double for the last few minutes, and you're saying, Kevin, I'm hungry. Well, hopefully you got some lunch coming in, and if you haven't, guess what? I bet you a lot of money. About half this group who hasn't had lunch yet is going to In-N-Out for a talk, including myself, because I haven't had lunch yet. So the secret menu of being a trustee is the California Probate Code. All right, it's a law. It's not a law, it's the law. And that's the secret menu. So people that we designate, usually children, family, other relatives, or the godfather, the best friend, the neighbor in some circumstances, all these people generally and usually are non-lawyers, or if they are lawyers, they aren't lawyers that practice in this area. It's super rare. And I think only one time in 10 years have I come across the fact that somebody wanted to name an attorney in their family or a friend that wasn't actually a practicing estate planning attorney. And it's extremely rare if they wanted to name him that person would say yes, because that person, if you want to ask me, like personally, not professionally, but you want to ask, hey, Kevin, I have known you for a long time. Would you be the trustee? I would tell you no. Why? Because I know all the ins and outs. I would tell you that I don't want to assume that kind of liability. It's not a horrible job. It's the right job for the right people, but you have to understand that there is a risk. You're adding risk to your life, whether it's a huge risk or a small risk, it kind of depends, but it's added risk. Because there's a secret menu, most people don't know if they're not in the law. They don't practice trust in estates. They don't practice probate. So you can go ahead and read the law, of course, but then most people won't do that, and I get it. I don't read the law in other areas in which I don't practice, unless I have to. Or what I really do is I go hire an attorney that knows that, right? So because it's hard and complex, it changes all the time. You could read it today, it'd be different tomorrow. It's this moving hidden menu. So that's what we help people with. They come in the office and they let us know that a parent has passed away or a friend has passed away and they've been named to be the trustee. What we're doing is really helping them maneuver what the rules of the trust are and letting them know what the secret menu is and helping them through this moving target of a secret menu. So the California law in this secret menu says you are a fiduciary. Now, just talking about personal responsibility, personal liability, this is why you have the big target in that shirt. Remember the present with the shirt and then going out, the target out. The reason why there's a target is because California law says you as a trustee are a fiduciary. You have a fiduciary duty. You have an actual legal duty and responsibility to do the right thing. Well, and to know what the right thing is. And if you don't know, you have a duty to go find out what the right thing is and then do the right thing. And sometimes it's not necessarily intuitive, it's difficult. And like I said, the laws are ever changing. So you're always doing this job while looking over your shoulder. You're doing this job, making sure, and there's a little anxiety to it, right? It sounds like, okay, am I doing the right thing? I better go to this professional. But if this is the right professional, are they charging too much? Because if they're charging too much, I can be responsible because the beneficiary is going to say, hey, you hired Joe Schmo, the CPA who charges 3 times over the normal rate. So maybe I better go interview a couple other CPAs to make sure that I'm hiring the one that has the best experience and it's a reasonable rate. Same with attorneys, financial advisors, all these things. So even down these little things, it's important. So you have to know what the secret menu is, what it means to have a fiduciary duty. Because if you abdicate, a big word, if you fail in your fiduciary duty, then you have just put the trust in jeopardy. And that means that somebody can sue the you as a trustee. And if you did not follow your duty, then you can be personally liable, which means they can come after your house, your investment accounts, and all that. No joke, we see it. Estate litigation, trust litigation is a booming industry. Why? Well, because there's a lot of baby boomers and people are that area of the twilight of their life, and the baby boomers are passing away more and more because there's just more of them. So there's more estates to litigate, and there is a lot more issues and problems because there's just more people that are doing things their own way. But this isn't Burger King, right? This isn't even In-N-Out. That was a joke with In-N-Out. This is the law, and the law says you can't do things your own way. And when you do that your own way, you don't know what you're doing, you're going to have an accident, you're going to have a mistake, and that mistake has consequences that could cost you everything. So, and these lawyers are ruthless. Some of them I know, they're great. I love them. They're wonderful. They stand up for people's rights, beneficiaries that are being jilted, that are being taken advantage of. They look to remove trustees that are having undue influence over parents and relatives that are still alive to do things, usurp properties, and just do illicit things. Um, and so we need those attorneys, of course, but we don't need the big expense of the litigation. And this is like ends up being like a divorce. Or someone going through a contentious divorce, that costs a lot of money, hundreds of thousands of dollars. So I have two examples in practice. One is a family where we had a mom and a dad and 3 daughters, and they did the birth order thing, and everyone gets along fine. The kids are all right. We don't have that much, like $2.5 million estate. Most of it was the house and Anaheim Hills, and the rest of it was some savings. Unfortunately, the parents died relatively young in their early 70s or in their 70s, right? There was a cancer, and then there was a heart attack. And all within 6 months, parents have passed away. Very sad story, but we have oldest daughter now, the trustee. Everything was going smoothly until they started dividing up the things in the house. And then there was an argument over a piece of furniture that was apparently a family heirloom. And all the daughters wanted, but of course, it's one chest of drawers, right? That was an antique. Can't divide that by 3 ways. They couldn't agree on what to do with it. They all sued each other. That has been in litigation for 5 years, no joke. And nothing set for trial. And that's a problem. It's costing hundreds and hundreds of thousands of dollars of the only $2.5 million estate, not the legacy that we want to leave. So we also want to look at what is if I say, okay, if I just follow the trust, it says this. So Kevin, can I just follow the trust? The trust says I don't have to give an accounting. It says it right here. I don't have to give an accounting. I bring that point up because I hear that, I see that a lot. I hear that a lot. In the trust, it says the trustee does not have to give an accounting to the beneficiary. Well, guess what? That's a conflict with the California law, because under the California law, if a beneficiary requests an accounting of the assets of the trust and the management of the trust, guess what? The trustee can't simply say, well, the trust says I don't have to, so go pound sand. No, the law says, hey, trustee, you got to do that. They ask for it. Hey, they ask for statements. You got to give them the statements. But they gave me this letter, and there's like all these things, and it's a lot. This is too much. I can't possibly do that. They're not entitled to that. It says no, no. It says no accounting. I'm gonna just rely on the trust. Well, guess what? You'd be wrong. Trustee would be wrong, and the trustee would be not following their fiduciary duty because they're not following the law, and they would be subject to a lawsuit. And they're subject to be removed in the lawsuit, and then subject to any sort of damages, certainly attorney's fees, but any other damages that might have caused. as well. Because if you're trying to do everything by yourself and you're trying to do the money management, there's bound to be some sort of mistake on there and how you're managing it, moving things, accounting for it. There's going to be a mistake. So get professionals to help know the law. And one of the professionals you can use, your successor trustee can use, is a trust attorney. That's what we do. We help set up the trust and we help implement the trust. So just know the trust isn't the end all be all. There's this secret menu that has things on there that says that these are the things that trustees need to do. They need to send notices out in a specific way, in a specific type format with specific language. It has to be done within 60 days of a death. And then there's all sorts of other dates and timelines that go along with that. Then your trustee has to know those. Saying, I didn't know that. I didn't know there was a law that said that I had to file this paperwork within on the real estate within 5 months, or I'm subjected to a 10% fine off the value of the Prop 13 value. I didn't know that. Why do I have to pay thousands of dollars out of the trust assets because I didn't file a form that I didn't know about? Too bad, the law says you have to pay. And guess what? You're personally liable for that because you should have known. The knowledge is imputed. So these are important things. You don't want to miss another important date, 9 months, 9 months after the trust. If there was going to be a disclaimer that was issued, hey, I have beneficiary. I don't want that for whatever reason. It might be a good reason. I don't want that. I wanted to go to the next person. I don't want that because I want my kid to get that. And my child is the contingent beneficiary. So I'm going to disclaim that. Or I don't want that because I'm going to get taxed on it. Or I'm in the middle of a lawsuit. I'm in the middle of a divorce. I don't want that. You can only do that disclaimer within 9 months. Once 9 months pass, sorry, too late. Well, I don't want it. It's 9 months and a day. I didn't know about it. Too bad. No exceptions. Same with some tax filings as well. Your trustee has to know that with minimum distributions out of an IRA, which now becomes an inherited IRA, 401k. There are timelines here that you have to know about. All right, I belabored that enough. So we talked about a little bit already general duties of the trustee as far as being a fiduciary, but here are the big three things that are responsibilities of the trustee. Number one, and this is in order, right? A timeline, because it's kind of what happens. Whether you passed away or you become incapacitated, the trustee, the first thing they have to do is be able to assert their power of being the trustee. They have to legally announce to the world that they are now the trustee. So that has to have some supporting evidence. The fact that you've died, that's easy. There'll be a death certificate. I say that's easy. Sometimes there's a delay in the death certificate, so we have to take some alternative measures sometimes in those situations. But assuming no delays, usually in 2-3 weeks, we have a death certificate. Now we can assert the fact that the trustee is now the successor trustee is now the legal trustee because we have a death certificate. A little more challenging in situations of incapacity because it'll determine upon um, the, uh, the definition of what incapacity means in the trust. Is it that there's two physicians, or maybe these old trusts, I've seen three physicians. I've seen all sorts of different requirements that have to be met before that person can be a trustee. So we have to meet those requirements and announce them to the world. Then the successor trustee is responsible for collecting assets. So bringing them into the trust. If they're outside of the trust, we had a situation where, oh, the house isn't in the trust. We got to get that house in the trust. A little bit easier to do sometimes if the person's still alive that owns the house and says it's in Bob Smith's name as an individual. Well, we want to get in Bob Smith's trust. Well, then the successor trustee will turn to the power of attorney for that. It might be the same person. They just switch roles and responsibilities, put on a different hat, legal hat, and then they could do that. A lot harder if now we've died. Bob Smith died, but Bob Smith's house is still in Bob Smith's name, not in Bob Smith's trust. So that's more of a challenge. Now your successor trustee and your executor, again, might be the same person, just going in with two different hats. Could be two different people sometimes, it depends. They're going to court to deal with that situation, more challenging, but they're responsible for going to court. They can't just say, no, I'm not gonna do it. Other assets, you gotta go to the bank. The bank's gonna freeze an account. You gotta get the money opened in the trust account. You gotta open a trust account. You gotta make sure that title's changed on property and get all those assets coalesced into the name of this trust moving forward. Your revocable trust becomes irrevocable, so they need to get a tax ID number. Again, bank accounts are going to be frozen because they're going to be in your old social security number under the revocable trust, not this new idea and concept of irrevocable administrative trust, which is what technically happens after you die. And there are no sole initial trustees living. Because if you die and you have a spouse that lives beyond you, then that's different scenario. But if you both have passed away, or you're a single person, you pass away, your revocable trust becomes irrevocable, which is technically a separate trust under the law. Under the tax law, requires a tax ID number. That's why bank accounts get frozen. And that's why the trustee has to undo that. Trustee has to pursue any sort of money that's owed to you. So you got loans out there to people. They got to go collect on those loans. If there's an outstanding legal case that you filed in which you are a plaintiff or you're a defendant, the trustee has to deal with that situation. If there is a legal action out of the reason why you died, there could be a wrongful death suit, and the trustee has to pursue that along with the personal representative. Again, that could be the same person. We have a situation now with it, that's the case. There's a question about how this person died. They died seemingly accidentally, certainly surprisingly, definitely early, 63, and she wasn't supposed to die. She died unexpectedly. Was there some fault? Is there some legal action? If you just stick your head in the sand and don't do anything, guess what? There's going to be some personal liability there. You gotta know what it is that you have to do. You can't ignore that. You got to give notice, and you got to know who you're giving notice to in a certain way. You can't leave anybody out. And you got to give notice to the world. Maybe notice to certain creditors out there. You can't just operate the trust and say we're only going to let the beneficiaries know what's going on. No, there are other people, potential heirs, other family members that are out there that you have to let know. And sometimes we want to let potential creditors know because we want them to not act within a statute of limitations, so that they can never come after the estate anymore if they don't act within a certain time period. So there's all sorts of things that we need to do in that first step. The next is we have to pay off debts. We have to pay off taxes. So sometimes the taxes, that's confusing, because do we file an estate tax return? The trust now needs to get a tax ID number. We got to file a trust return. But what about Bob Smith, who passed away? Well, we got to file a return for him as a person. We have the return for the trust. Then we have the estate tax return, which is completely different. And that's something that you might want to file not only if you have a lot of money, and we have to deal with potential tax to the IRS that needs to be paid because you have an estate that is over certain numbers. But then there is also the fact that you might, if you're a surviving spouse, you might want to freeze and hold the estate value, that the gifting power that your spouse didn't use, and you still need to take a return. Then you got to give distributions out to beneficiaries. Oh, it says a third, a third, a third in the trust. Well, how do we get there? Because there was just a house and a little savings. Do all three own the house? Siblings going to buy each other out? How are we going to get there? Okay, so even in a simple state where there's not much, there's just a house and some savings. Trust is the way to go, of course, because otherwise that land in probate. But that could be a complicated scenario due to dynamics. Everyone has a different idea what to do with the house, and of course, we don't want to just have three people owning the house necessarily, because everyone's going to have a different. I want to live in it. We should rent it. We should just sell it. I need the money. And so we have conflicting interests, even when beneficiaries are good friends, the siblings are good buddies. Now that's where circumstances come into place. Well, I need the money. We need to sell it. Well, we shouldn't sell it. Can't you just get along with the rent? And no, I want to live in it. I was always counting on living in this house. Well, how does that person buy the other two out? So those are things you got to figure out, down to complex assets that get distributed into maybe continuing trusts for other beneficiaries, particularly minor beneficiaries. Now, how does that happen? How do we get to the percentages that were allocated when we have assets that are in brokerage accounts? We have assets that are in inherited IRAs. We have assets that are businesses and things like that. We have to deal with those distributions. We have to come up with a plan. So we got to work with a team, because if you try to do it by yourself, then you're going to mess it up, particularly the estate tax returns. Even on a simple a trust and estate, that could be complicated. And then, of course, you got to file the tax returns, and the tax could be an issue. And if you mess up the tax part, guess who's personally liable? The trustee. So if you mess that up and there's some back taxes owed, the estate is audited, and the IRS comes back and says you didn't pay enough tax, or you thought you didn't have tax, but you actually do have tax, and you distributed the entire estate. Well, good luck contacting the beneficiary and say, hey, I got to roll that back. Can you give some of that back? Because it might not be available. Maybe they use the money as a down payment on a house and they don't have the inheritance anymore. They spent it, lost it, whatever, or they're just unwilling to give it back. Guess who's stuck with the bill? You are stuck with it. And even if you get the money back, the beneficiaries can sue you for not doing your job. right? So we want to be clear of using vetted professionals, accountants and CPAs that have done trust returns, that work in trust administration, not just H&R Block or other just tax preparers of 1040s. Not there's anything wrong with them. They provide good service, but if they don't have the experience of dealing with trust, then they're not the right CPA or accountant for you. Don't just say count on, oh yeah, we can do it. How hard can it be? It could be really hard, right? So beneficiaries have rights. Trustees got to follow those rights. They have the right to know what the heck's going on. They have when there's a change in trustee or any, they have a right to inventory of assets. They have a right to object to how things are being distributed. So you can't just go off and sell the house without informing the beneficiaries with a notice of action saying we want to sell the house, because maybe they're going to object to it. Say, hey, we want to live in it. We want to wait, hold, slow your roll. I want to buy out my siblings. Don't go sell the house. And if you do, guess what? You're a target for being sued in that situation. They are due an accounting and they're due timely distributions. So, and here's what does timely mean? I'm asked. Well, timely is reasonable, number one, but once you hit a year mark and you haven't distributed assets, those assets start to accrue interest under California law. Again, knowing the law, the hidden menu. Oh my gosh, you didn't know that. No, shoot. Now I have to pay out interest to this beneficiary because I didn't move this trust along quick enough. And who's going to be personally liable for the interest? You, as or your successor trustee, is going to be personally liable for that. So trustee to-do list, and we'll get all this to you. All right, if you stick on, because we have a special handbook for you. We talked about a lot of this already. You got to establish your authority. You got to lock up assets, get authority over them. Sometimes that literally means changing the locks in houses, because what is the first thing to go when someone passes away? They come in to mom and dad's house, the relative's house, and they do a walkthrough, and better check their pockets before they leave, or their backpack instead of a metal detector, because I bet you they have something. I'm not cynical. I just seen this. Seen it in my own personal life. I've seen it in the clients' lives. This is what happens. Oh, I really like it. This was always meant to be mine. Mom said it was going to be mine, but they're not allowed to take it yet, right? Until they. So you have to prevent them from doing that. Because the last thing you want one person in the family to do is take something that wasn't going to go to them or hadn't been decided yet, and some other family member wanted that. Now you have an argument, and you did not do anything to prevent them from taking it. So you contributed to that chaos as well. And again, you can be personally liable for that. So if you have a co-trustee, in the situations where there are co-trustees, we not a big proponent of co-trustees, but there are co-trustees. It does make sense in certain circumstances. So never say never, but not a big proponent. And certainly trust where I see it most is trust that we haven't done. There's co-trustees. Make a good relationship. You can really like that person. Make a good relationship with them, at least professional one, because you don't want them to go lawyer up, because then you're going to have to lawyer up. And now administration of the trust is dealt with by two lawyers, and now it's going to be more expensive because guess what? The trust is paying for those lawyers. I have a case like that. I am one of the lawyers. I represent one of the co-trustees. There's a lawyer on the other side representing the other one. And every little thing we do, two lawyers get involved, and we bill for that time. And rightfully so, but it is expensive. So they didn't have to do that if they had a good working relationship. Same with beneficiaries. Be transparent, be communicative, keep them up to date. Any potential disputes, resolve them beforehand. One thing that we do here is dispute resolution. We're not mediators in the legal sense, but we don't like to just march off to trial or send people over to our friends, the estate litigators, at the outset. Sometimes we have to, and we get referrals. There's nothing we can do, or we exhausted all our remedies. But we really try to ramp down those disputes, and we work with trustees and beneficiaries to do conflict resolution, and people hire us for that conflict resolution, because that'll be less expensive to resolve the dispute, be less expensive not to have the dispute. So really get down to the nitty gritty and get in front of that, because it'll be way more expensive if you stick your head in the sand or you create a dispute. Get your professionals lined up. Don't engage in self-dealing, meaning, oh, I'll take a loan from the trust because I need the money right now, and this investment is going to be great. I'll get it back. Or I'm going to, as a trustee, I'm going to buy that property. That's self-dealing. It is not legal to do self-dealing in most states. even if the trust says, again, we have a conflict of laws, we want to resolve that conflict of laws before you do anything like that. Don't allow a conflict of interest. So don't, if you're a financial advisor, do not manage the trust assets. Get somebody else to do it. If you are a beneficiary or trustee and you're also a lawyer, like if I'm named as a trustee somewhere in someone else's trust, I'm not going to provide legal advice for the trust. I'm simply going to be an individual. We're going to work with another trustee. Um, and a lot of times, this is the biggest one where people get into problems, is we have named the kids as the trustees. They're also the beneficiaries. So you have you have a conflict. You're the trustee with a fiduciary duty to manage the estate on behalf of the beneficiaries for everyone's benefit. And you're also the beneficiary. So as a person, you have an independent vested interest in your inheritance through the trust. Sometimes there's a conflict, and decisions you have to make on a financial or legal perspective should not be done with the lens of this would be good for me as a beneficiary. And sometimes that is difficult to do, to separate yourself. So maybe sometimes you don't don't allow yourself to continue as a trustee, and there might be provisions in a trust to say, hey, I can bow out and appoint a neutral person instead, or at the very least I'm going to bow out and let somebody else do it, but I don't want my sibling to have a conflict of interest, or I can't because my sibling who's named is in the middle of a divorce or has a drug addiction, or just is in jail. Sometimes we have those. So the construction of the trust is important to deal with these contingencies, to empower your trustees to resign if it's not a good idea, but not leaving that trust high and dry. Like, oh my gosh, if I resign, there's not going to be a trustee because there's nobody behind me. To have those provisions set up, so it's setting your trust up for success, setting your successor trustee up for success. Don't take unreasonable compensation. Don't pay yourself a lot of money. You can pay yourself if the trust allows for that, but a lot of these trusts say reasonable fee. Well, what the heck's a reasonable fee? Get advice about what a reasonable fee is. Have a lawyer tell you that. Put in writing, this is what a reasonable fee is, because if it becomes pointed out unreasonable and is found to be unreasonable, somebody else gave you that advice, and it's certainly reasonable for you to rely on an attorney to tell you what the standard is. So you can pass the buck to them. So they were unreasonable in telling you that. They committed malpractice in telling you that. They told you you can take a 1% value of the estate when it only says reasonable fee. You don't want to take money from the estate without checking, right? Whether you're giving it to somebody else or giving it to yourself or paying off a creditor, you don't want to take money out of the estate without checking with a professional of whether that's a smart move. Great example is, well, mom had $15,000 of debt on the Amex. So I just paid off 15 grand of the Amex. What? You did that without asking? Because if I were to tell you how to do it, you could have talked to American Express, you would have talked to the people in the estate department, and they probably would have given you a deal and said, hey, if you can pay $12,000 right now in full, that'll cancel the debt. You would have just saved the trust 3 grand. And that you could be personal liable for that 3 grand. So even little things like that, it's important to go through professional. Keeping records is important. So somebody is not detailed or messy or in their life, just look at their desk at work or at home. If it's messy, probably not your person. You need someone who's type A, anal, retentive in this area. Keep good records in accounting and work with people that are. People that just don't have good relationships are not going to communicate, or they're bombastic. This would be a great person to be the advocate for me in court, or he or she's a bulldog. Wonderful, but not for this job. You don't want to alienate people. We don't want people to just stick their head in the sand and say it's all going to work out, but not do anything, or be the people that are overly litigious and they run out and hire a lawyer, not a litigation attorney. So that's important. So how do we avoid all this? Bringing this to a close is we want to be able to make sure that your trust is going to work well for you. Your successor trustees are set up for success, and they're the right people for the job. We can only do that by servicing your trust, just like you bring your car in for service. And if you don't change your oil, you don't go in for the 10,000 or 20,000 mile services, you don't change your tires, all that stuff. Guess what? The car's going to not work anymore. It's going to get run down, get in a big accident, or just not start. So we don't want to buy the car, stick it in the garage, leave it there, and the car being your trust, and hope that years down the road when we die or we're incapacitated and we need someone to drive that car, that it doesn't start because you haven't serviced that car in years and the battery's dead and you can't pull it out. And guess what? It's a useless car. So service your estate plan by having it reviewed periodically. We like to look at it every year. I like to look at mine every year, my estate plan, just to make sure that things are still the way I want it. Maybe I have a different viewpoint. Um, Maybe I don't. Do I change my trust every year? No, but I look at it, and so I know where it is and what it says. And that way we can jump in and make the updates when necessary. So you service your car more than once a year, right? So same with your trust. Because we want your loved ones to be driving a car that's going to work and a car that's going to be safe and not a car that's going to get in an accident because the accident's going to hurt them and others. So there are some new laws that are out there that you need to know that are super important because they're still brand new. Even at a few years old, they're still brand new. Number one, there's this thing called an empty chair. That means that if you have a trust in your parents, let's just take your parents, mom and dad have a trust. Dad died, mom's alive, mom's in memory care. Guess what? That trust is now irrevocable. Whoever's the trustee is the successor trustee acting. That successor trustee has to give an annual accounting. Before that wasn't clear. It was only after after the death. Now it's after an incapacity. There has to be an annual accounting. So you got to know that. That's part of the hidden rules. Uh, Now, the AB 2747 that went into effect this year, trustee has a fiduciary responsibility to the beneficiary, of course, as we talked about, but also to the tenant. So if the trust has assets that's like it's a triplex or an apartment complex, even a single family home that's being rented, and the trust has tenants, guess what? Now, as a trustee, you are also the landlord and you're also liable personally, just like a landlord, just like you owned it. And that's an important distinction, and it comes by way of law, not by case law, circumstances. It's law. So you're taking on an additional liability. Maybe you don't want your kids to have that liability. Maybe it's better to have a professional fiduciary or a corporate fiduciary if that's the thing. And then, of course, there's all sorts of income traps that come along with it. So the top 10 things that you need to know as a successor trustee, take a screenshot here as we close out this webinar. Super appreciate. Oh, Kevin, wait, you said if I hung on, I would have something special to talk to you about. So that secret, right, in and out menu, we want to provide you that menu. So what we've gone ahead and done is we created a successor trustee manual. All right, this isn't the trust. You already have the trust or you have your trust, but this is a manual for your successor trustees. And it is a detailed manual. All right, this is over 120 pages long manual. It really goes into detail of all the things that your trustee needs to know about. Basically, the written out version of what I talked about today. All right, so normally we sell that. We do sell this out there for $199, but because you were on this webinar, you got to the end here, you got the offer. Now you can get it for $99. So $100 off there, which is 50% off, basically. We're doing that. Look, it says Friday, February 28th. So we have a deadline for this. So if you're watching this later because someone sent it to you, because we are recording this, or you're watching later in recording, and you missed February 28th, then you've missed, maybe you haven't missed anything, give us a call, we'll talk. But look, for you guys now that are here on the webinar, we're really not extending this offer. We're going back to normal pricing. So if you want it for $99, it is extremely valuable. It will be super helpful. It's updated up to 2025 standards. Just scan the QR code, go to the website, and you can purchase it right by following the prompts. All right. So that's my gift to you guys for just listening to me today and sitting around on your lunch hour on a Friday on a beautiful day, learning about this important information. Thanks, everybody. Go off, and I hope you all have a great fun weekend. It's going to be nice weather out there. It's warming up a little bit. So go have fun and keep being amazing.